Oh, good times. Okay, so before we transition into this slide, one of the questions I got from Kurt Fisher, if you provide sick hours, so 40 hours at the beginning of the year, they can lose it at the end of the year, is the
That is
question?
correct. Yeah. So, Kurt, what you're asking is a front loading process as opposed to an accrual process. You are permitted to front load 40 hours at the beginning of every calendar year, anniversary year. Heck, you could pick some random date that you just absolutely love during the year and say, we're front loading your 40 hours. That then becomes a use it or lose it. Because if the employee does not use it by the following January 1st, they just get refreshed with a brand new 40 hours as of that renewal date. The one thing I will caution you on this is that for 2024, it is going to be a little bit of a hiccup for a lot of folks who are front loading, because employees are going to say, well, I didn't know that I have lost my prior year's accrual. Do I not get to roll that over? And the answer is no, they do not get to roll it over. They just get the 40 hours for 2024, and you may have a little bit of an employee complaint issue. The one last thing I want to hazard employers on front loading their time, especially if we're talking about January 1st, do not be surprised or shocked that between December 25th and January 1st, people aren't feeling well. When employees know that they've got a benefit that they're going to lose, they will tend to use it for you. So if you have a production operation or a manufacturing facility, and that last week of the year is important for you to have attendance in place, you may want to think about moving it from a January 1st date.
Okay, that's great advice. All right, well, so we just finished that section, and I know we now have this next section on here, and we're kind of pausing to make sure as we for future video, we want to make sure we actually can put this into chapters, and so I'll let you set this one up in terms of California employment law.
The second area that we see the most claims, the most number of litigation matters, the most claims that come forward in front of the California Civil Rights Division are hinged around these ideas of leaves of absence and accommodation. And we have some new changes for 2024 that employers have to be aware of and be proactive in addressing this, not just in writing a good policy, but making sure that your team members, your management team, your leaders, your supervisory staff all know about these rules, because they are your front line of defense. You want to make sure that you're doing a training for your management level employees, so they know that this is coming down the pike. The first we're going to talk about today is reproductive loss leaves. This has been a big push from the legislature for the last 2 or 3 years, and they finally passed a bill in September that basically provides that an employee who may suffer a reproductive loss, that could be a miscarriage, that could be a stillbirth, or failed adoptions, failed surrogacies, unsuccessful assisted or IVF reproduction, all of these trigger a new leave requirement under California law. This leave is protected under the California Family Rights Act, CFRA. And so therefore, this will apply to all businesses that have 5 or more employees across the board. And remember that this is presumed to be a bereavement leave. The employee has suffered a loss, and we are providing them an opportunity to take job protected time away from work in order to grieve, in order to deal with their sorrow and their pain. California has set this up such that an employee is entitled to receive 5 days of unpaid leave for every loss that they occur within a 12-month period. An employee may suffer up to 4 losses. So they could have multiple miscarriage scenarios. They could be attempting to adopt and things fall apart at the very last minute, and you must allow them to be accommodated up to 4 times a year with a maximum leave in any 12-month period, 20 days or less. This applies to any employee who's worked for you for 30 days. So at day 31, and they advise you that they've suffered a loss, you must accommodate the leave requirement. The leave must be taken within 3 months of the actual loss date. So if they suffered a stillbirth, for instance, and they decide that they don't want to take it right away, but they want to take it a few weeks down the line, you must permit that. Additionally, it does not have to be 5 consecutive days. An employee does have a legal right under this new bill to basically say, hey, I'm going to need to take the next 5 Fridays off. in order to be able to go and attend therapy sessions or go see my doctor or whatever is necessary. And that is a reasonable accommodation under this new obligation. And then the last point is, while this leave is unpaid, the employer must allow the employee to utilize any accrued paid time off, vacation, or personal sick leave should they choose to use it. An employee may elect to take it as unpaid, but if they ask to be paid and to use their time, you as the employer do not have a right to deny that. Finally, I've got my reminder at the bottom. Make sure you have updated your employee handbook. This is point number 3 of the changes that must be made to your employee handbook for 24. Make sure you've got a policy in there that lays out the employee's rights so that they're educated and advised on their rights, because if you don't have a written policy, it is presumed you are not offering it to your employees, and therefore you're out of compliance with the law. Cannabis use. I talked about this briefly last year, but we got some regulations on this year, except for those of you who are in construction and building, those of you who have federal government contracts, or where if you're a supplier in the chain of a federal government contractor, when you're conducting a background investigation or a drug screening, whether that's before the employment period begins or during the employment, we should no longer be testing for cannabis in the bloodstream. Why? Because the legislature says we don't have an accurate enough test to tell whether or not someone is actually under the influence of the psychoactive elements, THC, in the bloodstream at the time of, let's say, a workplace accident or a reasonable suspicion test. What I am advising at this stage is, if you are running drug screenings through Concentra or an urgent care facility or MedCore or something along those lines, I no longer have my employers screening for cannabis containing products unless you have the employee in a safety sensitive position, are in construction or building, or have a federal government contract. It is too difficult for an employer to track. It is protected under the Fair Employment and Housing Act, as basically it presumes that you're discriminating against somebody for exercising their recreational right to consume cannabis in their own personal time. So make sure that you've updated your policies such that if you do test for cannabis, that you specifically indicate when and why and what type of test is being conducted. And then also I want to flag that new for this year, if you have any questions on your application for employment or in your interview screening process for employees related to personal cannabis use, you must take those out because they are now deemed unlawful under the state of California regulations.
Okay.
The other huge change that we had for 2024 is that now every single employer, save those that are ultra small, those with 10 or fewer employees, must have a separate written workplace violence prevention plan. Much of this stems from workplace violence that has arisen most recently in fights, workplace shootings that we've seen, and other claims of threats of violence in the workplace. This will require a written policy. You must train not just your management staff, but all employees on your workplace violence prevention plan. And that training and the policy must be issued no later than July 1 of this year. Now, we do not yet have a model plan drafted by KOSHA. We are supposed to have it sometime in March or April. I've had many clients call me saying, can you help me put this together? And my statement to them is, wait, we need to see what the model plan looks like from KOSHA, because there will be unique aspects of what KOSHA expects to see that we cannot necessarily forecast right now and tell you with any accuracy that a plan that we put together today will be 100% compliant. So once that model plan drops, we'll all be put on notice of it. I'll be glad to send out email notification if you'd like to receive it so that you can see what that model plan looks like. We design the plan around the KOSHA recommendations. Then we train our employees. I believe personally that this deadline of July 1 is going to be extended by about 3 to 6 months by virtue of the fact that KOSHA is now telling us we probably won't see their model plan till April. Employers have to have time to be prepared for this. But the keys behind that, just real quickly, are going to be, you have to have a plan in the event of emergency or disaster or any kind of material threat of violence. You're going to need to have a lockdown plan. You're going to need to have security. You're going to need to have something in place that if this happens in your business, you are prepared for it.